recorded live.
All right, welcome everybody. My name is Matthew, and I am the moderator for our Wednesday night calls, The Free Americans. And our host tonight is Christian Walters. We are talking about trusts. Before I turn it over to Christian, I'm going to go ahead and read Christian's disclaimer. This show is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making legal decisions or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show is for academic information purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein referenced, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as a liaison to communications between the parties. By listening to the call tonight, you acknowledge and agree that you are not a client of Christian Walters. The show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. And with that said, I'd like to turn it over to Christian. Can you hear me?
Yeah, Matt, can you read me okay?
Yeah, you sound great, Christian. So where are we starting tonight?
With the Gilbert's Law Summaries book on trust by Edward C. Halbach Jr. on page 43. We're picking up with number 3, beneficiaries.
All right.
So under that section there, page 43, section 3, there are beneficiaries. A, necessity of beneficiaries. Number 1, private trust, section 163. To create a private trust as distinguished from a charitable or, if recognized, an honorary trust, and you want to see this section's infra 169 through 176, the settlor must name or otherwise describe one or more beneficiaries, and that's individuals or eligible legal entities. So really, I guess another corporation can be a beneficiary under a statutory trust. So a legal entity, and capable of acquiring a property interest and becoming an obligee. An intended trust will fail if it has no beneficiary. Without a beneficiary, there is no one capable of enforcing the trust, and as there must be for a valid trust, a private trust, and it therefore fails. Page 44 says exam tip. Recall that trust will not fail for a lack of trustee. However, a trust cannot exist without someone to enforce it, and thus a beneficiary is necessary to the validity of every trust except charitable and honorary trust. If a trust fails for a lack of beneficiary, a resulting trust in favor of the settlor or his successors is presumed. Section 164 under A there, provisions satisfying beneficiary requirements. It is sufficient to satisfy the requirement that there be at least one beneficiary if there is one or more of the following. Number 1, beneficiaries named by trust terms. 2, beneficiaries so described as to be presently identifiable from extrinsic facts or evidence of extrinsic facts is admissible, example, as a fact of independent significance in the case of a will, and see will summary. Or 3, beneficiaries to become ascertainable at a future time. Example, for those of my issue living 20 years after the death of X, as long as they will become ascertainable, if at all, within the period of the appropriate rule against perpetuities. Modest authorities require that there be at least one presently identifiable beneficiary. Number 1, unborn beneficiaries, 165. So this requirement is satisfied even if some, or by the better view, all of the beneficiaries or classes of beneficiaries are presently unborn. Number 2, beneficiaries to be selected by trustee, section 166. It is even all right if the beneficiaries are to be ascertained by the exercise of the trustees or others' discretion, as long as under traditional doctrine, the class among which the selection is to be made is reasonably defined or will become so within the perpetuities period. Section B, trustees' awareness of intended beneficiaries, Section 167. The trustee need not actually know who the designated beneficiary is, as long as the beneficiary is capable of being identified when necessary. Example, where the trustee is handed a sealed envelope at the time the property is transferred to the trustee, who agrees to hold in trust for persons named therein. And C, on page 45 now. The effect of lack of beneficiary, Section 168. Where a private trust fails for lack of a beneficiary, for lack of properly ascertainable beneficiaries, there is a resulting trust in favor of the transferor or his heirs or other successors in interest. There's a couple case sites there, and one of them was unless consideration was paid to the transferor or for transfer, and another case site there was based on the trustee who paid consideration allowed to retain property beneficially. 2, charitable trust, Section 169. Identifiable beneficiaries are not required for charitable trusts. The Attorney General or similar public official enforces such trusts. So that kind of brings in the reason why they had the U.S. trustee. Number 3, honorary trust, Section 170. Many jurisdictions allowed the voluntary carrying out, but absent a statute, not the enforcement, for purpose trusts or honorary trusts that are neither charitable nor private. In fact, even if allowed at all, they are not recognized as real trust in the strict sense of the term. They are a device usually intended to allow, generally without enforcement, the carrying out of the certain objectives that are not private and that fall short of being charitable. A classic example is an intended trust for or an impermissible bequeath to one's pets. Another honorary trust purposes have involved the maintenance of graves, and now usually permitted by statute, or the funding of masses, now usually a religious charitable purpose. Now the example, testator bequeaths to residuary estate to, quote, brother in trust to care for my dogs and cats. The trust is clearly not charitable because it is broad enough to be charitable because it is only for testator's pets, in contrast a properly charitable trust for stray dogs and cats, inference section 550. So nor is the purpose enforceable as a private trust because there is no beneficiary capable of enforcing it. The beneficiaries are the pets. A, the strict view, section 171. A few American jurisdictions still appear to refuse to recognize such a transfer as a trust or any sort and hold that the intended purpose fails and cannot be implemented, even voluntarily, by the transferee, so the brother in the above example, who holds on a resulting trust for the transferor, that would be the testator's heirs. The intended trust also has been held to violate the common law rule against perpetuities at its inceptions as the, quote, lives in the being plus 21 years cannot be measured by animal lives. And there's a case cite there to support the invalid dispute wait and see statute. Next page, 46, B. The lenient view, 172. In English case, many Americans' decisions have recognized this type of disposition as an honorary trust, although it is not enforceable as a trust. I want to see that case there, and where it refused to extend the doctrine. That is, for some appropriate purpose, such attempt but defective trust will be deemed to confer an unenforceable power upon the transferee to allow him to carry out the intended purpose if he is willing to do so. And there's the restatements there in the second and the UTC quotes where in the absence of legislation, honorary trust probably cannot last for over 21 years because of the rule against perpetuities. Number 1, Effect transfer may carry out purpose under Section 173. If and so far as the transferee voluntarily carries out the purpose, he will be allowed to do so and no one can object. But if he fails to do so, or after he has carried out the purpose, he holds the property, or what is left of it, on a resulting trust for the transferor or a transferor's successor in interest, example, the heirs. The example here is same facts as the above example above, except the jurisdiction applies to honorary trust doctrine. The brother is allowed to carry out the testator's purpose, and if he does, the testator's successor cannot complain, at least not for 21 years, or until the brother has rejected or abandoned the purpose. Abandon the purpose. I wonder why they do a 1099-A on the banks with the proposed borrower. But the brother cannot retain the property for his own use. Number 2, interest created. Under A, traditional view, 174. Under the traditional honorary trust doctrine where it is recognized, the interest under testator's will could be described as follows. The residue of testator's estate ultimately belongs beneficially to the heirs by resulting trust, subject to a power in brother to apply, if he wishes, funds only to the care of the testator's dogs and cats. And B, the third restatement's view, section 175. The third restatement views the brother as a trustee with a usually non-mandatory power exercisable for a stated or a reasonable time to apply trust property for the designated purpose. A reversion in trust in testator or her successors and a right to enforce brother's administrative duties is implied or construed by law regarding any excess or remaining trust property. Next, page 47. The UTC view, the Uniform Trade Code, or Uniform Trust Code, section 176. Under the UTC, the transferee of intended trust for pets, brother in the above example, is considered a trustee with a mandatory power to allow or to apply trust property for the designated purpose exercisable until the past surviving pet dies. UTC section 408A says that, and then all other types of honorary trust are enforceable under the UTC for 21 years by a person named in the trust instrument or appointed by the court. C, distinguished. If precatory expressions, example, I hope, I wish, I request, are used, and if no trust intent is shown, so it has to be that plus that, no trust intent shown, the transferee can disregard the suggestion and retain the property outright. Thus, if the transferee wishes, he may carry out the transferor's suggestions not as an honorary trust, but because he is free to do so as owner of the property. The exam tip then. If you encounter a fact pattern on your exam in which the transferor purports to leave her property in trust for the care of her pets or the maintenance of her cemetery plot, think honorary trust. If the named trustee is willing to perform his duties, he will likely be allowed to do so. But if he is not willing, or once the purposes have been fulfilled, example, the pets have died, a resulting trust arises in favor of the transferor or her successors. Also remember that in absence of a statute, many jurisdictions will avoid an honorary trust on the basis of the rule against perpetuities if its duration may be more than the human life in being plus 21 years. So B, who may be a beneficiary? Section 177. So broadly, any person, natural or artificial, that'd be straw man, who is capable of taking and holding title to property may be a beneficiary of a private trust. I want to see restatements of third, section 43. Number 1, minors incompetence, section 178. So thus, minors in incompetence may be and often are beneficiaries because they have capacity to hold title. Now, we talked about this once before under capacity, where incompetence can have and hold, but they cannot administer a trust. And number 2, then, continuing on, unincorporated associations, sections 179. At common law, a trust in favor of a partnership or other unincorporated group would fail unless a gift was construed as a class gift to the partnership or group's members. A. Entity theory. Section 180. The trend today is to treat unincorporated associations as legal entities for at least some purpose, example, to sue and be sued in the group name or to hold title to property. Accordingly, they now generally can be trust beneficiaries. And these unincorporated association, example for those might be an association and a homeowners association. I know of a particular case where the association foreclosed on a property for association dues, but the party that sued in court was the corporation and not the association name, although it had a similar title to it. So the association didn't really, or the unincorporated association really didn't bring forth the action. Another fiction corporation did. Page 48. Non-charitable association, section 181. Nevertheless, a trust for the continuing benefit of a non-charitable association may present special problems in the rules against perpetuities because it has neither the immunity of a wholly charitable trust nor is it tied in duration to a period measured in relation to human lives and the being. And there was a case cite there, State of Shaw, trust to pay income to the Masonic Lodge held void. Now there's a little block there, the capacity required to serve as trustee or to be a beneficiary, where it lists the type of person and the capacity required, and then it lists the trustees and the beneficiaries. So the trustee has to have the capacity required to take and to hold title and to administer the trust, where the beneficiary is to take and to hold title. And both of those have to be, say, an adult. Both of those can be corporations, and both of those can be partnerships, and then minor or incompetent. To be a trustee is no, and to be a beneficiary, yes. So section C, who is a beneficiary? The problem of incidental benefits, sections 182. Not every party who stands to benefit through operation of a trust is regarded as a beneficiary of it. If the trust only incidentally benefits an individual or an entity, that natural or legal person is not a beneficiary, cannot enforce rights thereunder. An example, if a trustee is directed to invest a portion of trust estate in bonds of a particular corporation, the corporation is not a beneficiary and cannot sue to compel the trustee to follow the direction. See Scott's on Trust, sections 126. The beneficiaries can, however, surcharge the trustee for damages. So surcharge the trustee for damages, if any, result from the breach of the duty in failing to follow valid trust terms. And in the next example, if the trust provides that its trustee is to employ X to perform services for the trust, authorities presume, absent contrary evidence, that the provision is for the best interest of the beneficiaries and not to provide the benefit of employment to X, whose benefit is merely incidental. Under this interpretation, X would have no right to enforce the provision directing her appointment. Only the beneficiary would have cause to complain if the trustee failed to follow the settler's instructions and they were damaged as a result. There's another case cite that resulted the presumption may be irrebuttable if X is to provide legal services to the trustee. Next example. Suppose the conveyance is, quote, debtors to friend in trust to pay creditors of debtor, unquote. If this is construed as a trust, and some cases hold that it is mere agency, it should be considered a trust for the benefit of the debtor if the transferor with power in friend to pay debtors' creditors. The creditors are not beneficiaries and have no right to enforce payment unless the trust grew out of the creditor's composition or compromise agreement. Perhaps as a third-party beneficiaries of the dealings were contractual in nature, and see the contract summary. Otherwise, the trust would be terminable at will by debtor as sole beneficiary and settlor. In the exam tip, it is important to remember not everyone who benefits from a trust is considered to be a beneficiary. The trust must operate directly to benefit the person, individuals, and entities incidentally or indirectly benefited cannot enforce trust provisions. The requirement that beneficiaries be identified or members of a reasonable definite class, Section 183. So a valid private trust requires beneficiaries capable of enforcing it, and those beneficiaries must be ascertained or ascertainable when the trust is created, or certainly become ascertainable, if at all, within the period of the rules against perpetuities. The purpose of this requirement of identifiable beneficiaries is, ostensibly at least, to assure that the trust is or will be enforceable, which would turn ostensibly requires or will require persons who are identifiable as beneficiaries or as members of a reasonably definite and ascertainable class of beneficiaries. Number one, beneficiaries ascertained when trust created, Section 184. A beneficiary need not be identified or even identifiable at the date the trust is created. It is sufficient if the instrument gives a formula or a description by which the beneficiary can be identified at the time when enjoyment of an interest is begun. That time, however, must be within the period of the applicable rule against perpetuities. That is, under the traditional common law rule, it must be certain at the outset that the beneficiary will either be ascertainable so that his interest will vest within the period, or that the interest will fail by that time. In either event, there will certainly be an ascertainable beneficiary and an ability to enforce the trustee's duties either via expressed in interest or by way of resulting trust. For example, settlor's transfer, quote, to trustee and trust for sister for life, remainder to sister's children, unquote, is clearly valid. This is true even if sister had no children at the time the trust was executed. Whatever children sister later has will necessarily be ascertainable by the time enjoyment of the interest is to begin on sister's death. If there are no children, there will be a resulting trust for the settlor who is his successor in interest. A note. The same also should be true for 1, a trust executed for settlor's wife at the time when the settlor was still unmarried, and 2, a trust solely for after-born children of the settlor, or even 3, a trust for a corporation to be formed, example by the settlor, or within 21 years. B, status until beneficiary is ascertained, Section 185. If the as yet unascertained beneficiaries or beneficiaries are the sole beneficiary or beneficiaries, example S to T, that's settlor to trustee, and trust for children of B, beneficiary, when B has no children. 1, the minority trust invalid, Section 186. A few decisions have held such a trust to be valid. Next case there gives example, but this result is highly questionable and may be explained by the fact that the case involved taxation at a time when tax doctrine itself seemed ill-equipped to deal with appropriately with the situation presented by the trust if it were recognized. 2, the majority view, the resulting trust, here in Section 187. The more sound and usual view is the trust is valid and enforceable, and that until the beneficiaries are ascertained, the trustee holds tentatively on a resulting trust for the benefit of the settlor or for the settlor's heirs or other successors in interest. So this resulting trust is subject to the executory limitation which displaces the equitable reversionary interest, that is the resulting trust, and places equitable title in the intended beneficiary or beneficiaries if and when they come into existence, unless the settlor has reserved a power of revocation. The express trust cannot properly be defeated by a subsequent agreement between the settlor and the trustee. To attempt to do so would be a breach of trust. Now, he could come in and claim a mistake and reform it. C. Purported trust remainder to heirs of settlor for life beneficiary. 1. The doctrine of worthier title, section 188. Suppose settlor deeds to trustee and trust for brother for life and remainder to the heirs. In most modern jurisdictions, the settlor's heirs are remainder beneficiaries, individually unidentifiable with enforceable interest, nevertheless, so long as the settlor lives. The doctrine of worthier title invalidated a remainder that was limited to grantor's heirs. Therefore, in any jurisdiction that may still follow the doctrine of worthier title, there is, or presumptively is, no remainder in the heirs, but instead there is, or presumably is, a reversionary in settlor himself. When the doctrine has been treated as a rule of construction, that is, a presumption, it has generally been applied to personally as well as land as the rule of law, that is, as a prohibition. It applied only to real property. So really that's talking about a construment, they say a presumption. The rule of construction is to construe it or misconstrue it because you didn't express it. 2. Rule in Shelley's case, 189. Suppose settlor deeds or devises Blackacre to trustee and trust for brother for life and remainder to heir of brother. Today there is a remainder interest in brother's heir, unidentifiable beneficiaries of a nevertheless enforceable interest in a definable class so long as the brother lives. Under the rule in Shelley's case, now apparently extinct, a remainder limited to the life's estate holder's heirs is not recognized. And under some circumstances in those jurisdictions that follow the rule, brother, not brother's heirs, would have a remainder, and thus brother would have had complete equitable title merging into full legal title in fee simple. So here we're coming into some terms tying in the old 1888 book we're studying here. Legal title and fee simples. Fee fi-fo fum. I smell the blood of an Englishman. And how true those little nursery rhyme stories were. So continuing on. Technical rules of the common law in the block there, where it's going over the doctrine of worthier title and the rule in Shelley's case in application to the rule, the example, the result, the modern status, and the modern result. So the rule, the remainder to transferor's heirs is invalid. Transferor has a reversionary. And under Shelley's case, the remainder to life estate holders' heirs invalid becomes a fee simple. Now under the example, the doctrine of a worthier title, settlor transfers to trustee and trust for A for life and then to my heirs. And under the Shelley's case, settlor transfers to trustee and trust for A for life and then to A's heirs. And the result, under the worthier title, it is A has a life estate and S has a reversion. And under the rule in Shelley's case, A has a fee simple. And now the modern status, under the doctrine of worthier, it's abolished in most jurisdictions and it has been treated as a rule of construction, that is, resulting in a rebuttable presumption. And under the Shelley's case, the modern status is it abolishes in nearly all states. It's been abolished in nearly all states. And now the modern result, under the worthier title, A has a life estate and S's settlor's heirs have a remainder. And under Shelley's case, the modern result is A has a life estate and A's heirs have a contingent remainder because A's heirs are unidentifiable until A's death. Number 2, caution. Formal requirements must be satisfied for identification of beneficiaries of testamentary trust, sections 190. In the case of a trust created by the settlor's will, the beneficiaries must be identified with the will or in a codicil or by other administrable evidence, and see below. And the will or the codicil must be valid under the statute of wills. That is, the will must, along with other things, be executed in accordance with the applicable Wills Act. And similarly, inter vivos trust may have to satisfy the statute of frauds. See infra sections 302 through 346. A, reference to extrinsic writing, sections 191. Where a will does not identify the beneficiaries but involves reference to another document, that document must either satisfy the requirement of the applicable Wills Act or must satisfy the requirements of the doctrine of incorporation by reference. The doctrine which allows an extrinsic document not present at the time the will was executed to be incorporated into the will may be relied upon to complete the terms of the will. B. Reference to acts of independent significance, Section 192, where unnamed beneficiaries of testamentary trust are to be ascertained by a formula or a description. That identification must be based on acts of independent significance. Under this doctrine, a will may be disposed of property by reference to acts or events that have a significance apart from their effect on dispositions made by the will. See the will summary. An example, A bequeaths to Henry Axford in trust for such person as he believes most deserving for having cared for him in his last illness is enforceable. The beneficiary is ascertainable for circumstances outside the will that is an independent significance. In the cases of doubt, the court can receive extrinsic evidence to determine the person is entitled to take. So the block, determining definiteness of beneficiaries under private trust. To determine whether the definite beneficiary's requirement is satisfied, ask yourself the following questions. 1. Are the beneficiaries specifically named in the trust terms? 2. Are the beneficiaries presently identifiable from extrinsic facts, that is, incorporation by reference, acts of independent significance? And 3. Will the beneficiaries be ascertainable by the time their interests are to come into enjoyment and within the period of the rules against perpetuities? Now, page 53. Number 3, class gifts, sections 193. A private trust may, and usually does, at least in part, benefit the members of a class of persons. And these persons are trusted beneficiaries, and their interests are valid provided the designated class is described with a sufficient certainty that the membership is or will become reasonably definite and ascertainable within the period of the rule against perpetuities. A. Some special class gift questions. Number 1. Was a class gift intended? Section 194. Assume the settlor conveys to trustee in trust for directors of the XYZ Fraternal Society this gift to the directors as a class, or is it intended to be a gift to the association? Cases of this type are generally resolved by extrinsic evidence of the settlor's probable intent. And if the gift is construed as one to the association, this may raise the problem of whether the unincorporated group can be the beneficiary of the trust. Number 2, when is the class determined? Section 195. Assuming a class gift was intended, did the settlor intend to benefit the present and or future members of the class? This is merely a prominent construction of the trust instrument and is frequently encountered in gifts for persons' families. See below. The exam tip. If it appears that the settlor intended to benefit future class members, the identity of the future beneficiaries must be ascertainable within the period of the rules against perpetuities for the trust class to be valid. See future interest summary and see infra sections 241. B. Effect of trustee or other persons having power to select among class members, sections 192. Trust interests for members of class are normally uncomplicated, where a class membership is limited and definite, and where the class members receive the property or benefits in equal shares or in other fixed portions. Frequently, however, a trustee is given the powers, or perhaps couched in terms of discretion, to select and to allocate or apportion trust benefits among or one or more members of designated class. Trusts based on such powers are clearly valid if the class is sufficiently definite. But if the class is not sufficiently definite, A trustee's power of selection will normally not make the class definite or render the potential beneficiary sufficiently ascertainable to sustain the trust in many American jurisdictions. Continuing on page 54, number 1, the amount of gift needed to be certain in section 197. The fact that the amount distributable to each member of the class is uncertain, example, merely because the distributions are subject to trustee's discretion, even uncontrolled discretion, should not impair the validity of the gift. As long as the class itself is sufficiently definite, the trust will be upheld. A, trustee's discretion, section 198. If the trustee or a third person is given the discretionary power to dispute among the class, a usual interpretation is that the trustee has the power to do so selectively, that is, can give all or one or more of a class and exclude everyone else. These statements, the third on the 45 comment C, there is nevertheless the possibility that a particular exercise will be found to be an abuse of discretion. See restatements on the third, section 50. And B, successor trustee appointed if trustee fails to act, section 199. On the other hand, if the trustee fails or refuses or disclaims to exercise his discretion as to which members of a class shall take, the court may appoint a successor trustee who may exercise the power provided the court finds that the settlor would so intend, that is, the power was not personal to the original trustee, that trustee's non-exercise was improper, not want the settlor had intended to permit, or the court may, if deemed necessary, direct distribution as a matter of construction, having all members of the class share equally, or perhaps according to some other principle, such as that of representation or per strupes, if the class is someone's issue or descendants, and see Scots on Trust, sections 120. Number 2, power of trustee to appoint to himself, section 200. If language of trust is used or power holder is referred to as a trustee, and if a class of appointees is broad enough to include the power holder himself, example, to trustee and trust for himself or for other worthy person he may select, the purpose will probably not fail, although the class is indefinite, for the court probably will treat the transfer as a beneficial gift to trustee, allowing trustee to choose himself or anyone to have a property, or possibly referring to the trustee as the beneficial owner subject to the general power of appointment. So the Townsend versus Gordon case, where the courts, however, tend not to construe powers given to the trustees for vague classes. Example, to trustees as trustees for such of my friends as he deems most deserving to be beneficial to the trustees. Page 55, number 3. Non-mandatory powers contrasted with trusts. A power that is non-operative, that is not fiduciary in character, may be exercised or not entirely at the will of the power holder, the donee of that power. It is not a trust and does not require definite beneficiaries. That is, a power with respect to which the transferor did not intend to impose a duty and is generally valid as a power, that is, a power of appointment, and see future interest summary, regardless of whether the permissible appointees are, 1, unlimited so as to include the power holder, a general power, that is, and 2, limited to a definite class as a special power, or 3, limited to an indefinite class that does not include the power holder, perhaps a broad non-general or a hybrid power. Now the example, testator's holographic, which is handwritten will bequeath such of my jewelry as household goods as sister designated to such of my friends and relatives as sister may select, but sister has no obligation to do so, and if or so far as sister does not do so, such property shall be part of my residuary estate, which I bequeath in equal shares to my children who survive me, and if none do, then to charity. So sister has a power to appoint, but no trust is created. If sister exercises the power, the exercise will be given effect to the extent the appointees reasonably fit within the above quoted description, that is, do not exceed the scope of the power. If sister does not exercise the power, the property passes in default of appointment, and in this case as a part of the residue of the testator's estate. A, the powers in conjunction with trusts, sections 202. Although a power as such is not a trust, powers whether fiduciary, example discretionary, fiduciary powers or powers of appointment are typically created in connection with trust, that is, as just one of many provisions of a complete trust. Often a life beneficiary will be given an inter vivos or testamentary power of appointment. An example, transfer or bequeath to transferee and trust to pay the net income for niece for life, and on niece's death to distribute the principal to nephew if living, or to nephew's issue per stirpes, provided, however, that the niece's lifetime transferee shall distribute such amounts of income and principal, if any, as niece may appoint to any one or more or none of my friends. Andy, Beth, and Carl, as niece, may designate. As a trust, niece also has a power of appointment. Here the objects of the power, potential appointees, are definite, but they need not have been. Next example. Transfer or bequeath to transferee and trust for niece for life, and on niece's death, transferee shall distribute the principal to such one or more niece's issues and in such shares as niece may designate. And if niece does not designate, transferee shall distribute the principal to niece's issues per stirpes. Niece's power is not itself a trust, but is one of provisions of a trust. 4. Power does not require definite class, section 203. Although the powers of appointment in the preceding examples are exercisable in favor of definite group, Andy, Beth, and Carl, or a class, niece's issues, the group need not be a definite because the powers are not imperative. Example, niece could have had a valid testamentary power to appoint by will to anyone at all, including her estate, or to anyone other than her estate or other creditors as a common for tax reasons. The distinction between the powers of appointment and fiduciary powers of selection is explained in the third restatement, section 46, comment C. According to the traditional laws of trust, if the testator had intended to create an imperative power, that is a fiduciary duty to act, or at least to consider acting, that was to constitute a trust purpose and was to determine whose benefit for the trust, the class would have been a definite one so that there would be definite beneficiaries to enforce the trust, among whom distributions, if necessary, could reasonably be made equally or per stirpes by a court if the trustees improperly failed to refuse to act. If, as is usually the case, the power represented only one of the trust purposes and was not expected to exhaust all of the trust property, the court would replace the trustee who had abused her discretion. Now the exam tip. Remember, as long as the class is reasonably definite, the trust may authorize the trustee to exercise his discretion in selecting members to be benefited, or may provide that only those who meet certain requirements will benefit. Broad power to choose beneficiaries, however, may constitute a power of appointment rather than a trust. Next page, 57. C. What constitutes a reasonably definite class? Section 204. Whether there be a trust, class of beneficiaries must be definite enough that the court can determine, one, on whose behalf the trust may be enforced. Any member of a definite class of beneficiaries or permissible discretionary beneficiaries may bring suit. And 2, where the trustee has power of selection, whether the selection is within the authorized class, or if the selection is made, to whom distribution is to be made by distribution to all or some members on some principle such as that of representation. But see the restatement's third on section 46.2, intended trust that requires trustee to select from an indefinite class and thus no enforceable duty. and it's been treated as a trust with a non-mandatory power, that is, no duty to distribute, with reversion to extend unexercised. In the case of an intended power to appoint, a court need not only be able to, as a matter of interpretation, the event of a challenge, to determine whether an appointee fits within the class terminology used, and thus the entire class need not be definite. An example, my friends. Even in these cases, however, the same concept of definiteness may have some relevance. If there is no provision stating who is to take in default of appointment, a court will usually imply that the takers in default are members of the class, and all taking equally, or perhaps some taking first terpes. If the class is definite, but will not imply if the class is indefinite, so that there will usually be a resulting trust. Number 1, definite, Section 205. Most clearly, the following class gift terms describe a sufficiently definite class to serve as a class of trust beneficiaries or as implied takers in default. Children, brothers and sisters, nieces and nephews, heirs or next of kin, and issue or descendants. Cousins is already provided in court, provided the court will determine the degree of a matter of construction, that is, meaning only first cousins. Now, number 2, indefinite, Section 206. At the other extreme, the following references are not sufficiently definite to constitute a definite class. Number 1, to such persons as my trustee may select. Number 2, among such of my friends as the trustee shall determine. And 3, in the absence of a formula of reasonably objective criteria, to such persons as my trustee deems most appropriate. Number 3, location, Section 207. Although those resided or worked at the same address as the settler during his lifetime has been held to constitute a sufficiently definite class, and there's a case right there where it said the remaining uncertainties can then be resolved by interpretation. Next page, 58, family. We looked up last night on another call when we looked up familial, and there was 4 pages of definitions in the law book that the fellow looked up. So now family, Section 208. Family is not without potential difficulty, but it is generally so construed as to constitute a sufficiently definite class consisting of one spouse and children, and probably other persons living with the person whose family is designated in what is generally understood as a family relationship. So thus leaving further room for interpretation, which courts are likely to be willing to undertake as necessary. Example, to determine specific questions about inclusions of stepchildren, etc. Number 5, relatives, Section 209. Relatives, relations, kindred, and the like, family or more broadly construed than above, present more troublesome problem upon the authorities differ, as the terms may be considered too vague. How many degrees of relationship are intended to be included? Second, third, or 6 cousins? First cousins twice removed? Aunts and uncles? Great aunts and uncles? Step-nephews? Descendants or collaterals who have living ancestors between themselves and the transferor? A first step again is to decide whether to accept the class as definite, and if a court decides to do so, it will undertake the task inevitably involving guesswork of clarifying the settler's definite but carelessly vague class language. A, all relatives, indefinite, Section 210. If it is clear that the transferor meant all relatives, however remote, an intended trust would fail for indefiniteness of beneficiaries on the general rule. And this is traditionally has been so even though a power of selection has been given to the intended trustee. In a case right there stated that the power but no duty under the UTC, Section 402C. B, modern construction, next of kin, Section 211. Many and probably most courts today, however, will attempt to uphold the gift by interpreting relatives and the like to mean those that are the designated person's next of kin in existence at the relevant time, usually the time when the trust takes effect. And this would then constitute a sufficiently definite class of beneficiaries or discretionary beneficiaries to sustain a trust. The trustee and court selections compared, sections 212. A transfer upon a trust for such as my relatives as the trustee may select. Most courts apparently would sustain the trustee's designation of any relatives, that is generally by blood relatives, but that too is a question of construction and may well be narrowed or broadened somewhat by a supervisory court without limiting the recipients to next of kin. Case like there brought up, if the court has to take distribution because the trustee fails or refuses to do so, then the property goes to the next of kin. And the next case that brought up that this may seem incongruous, but the courts apparently seek not to restrict trustees' freedom of selection, while at the same time seeking to uphold the intended trust. And that's very important. That's always going to be done. Seeking to uphold the intended trust rather than that of the resulting trust arising. And this same analysis is used when the power holder has a power to appoint among an analogous class, fails to do so, and the question arises whether and how a gift in default of appointment may be implied. Now the block, definite versus indefinite class. Under sufficiently definite, going the other direction, not sufficiently definite, where it would be children and family and my friends, and then the issued or descendants, and the relatives in the middles, and then such persons as trustee may select. Brothers and sisters, and the opposite, such persons as trustee deems appropriate, and nieces and nephews, and then cousins and such persons at location. Number 6, failure of trusts for lack of definite beneficiaries, analysis, authorities, and review. A, powers under Section 213. Non-imperative, more properly non-fiduciary, power not intended to be a trust, is valid without definite beneficiaries because there's no need to enforce trust duties, and no need, although there is a class is definite, there may be an opportunity for the court to make a distribution upon failure to exercise the power. On this, the authorities are in agreement, and there is no frustration of the transferor's purpose to cause concern. B, trust with definite beneficiaries, sections 214. So a trust is valid where it is for the benefit of a definite class of beneficiaries or for such of them as the trustee selects. In both at the types of situations, it is clear that any member of a class may bring suit to prevent a trustee from absconding with or misapplying the property, or to surcharge for mismanagement, or otherwise correct a breach of duty. The court also knows what to do, if need be, to implement the trust. And on this, too, the authorities are in agreement. There is no frustration of the settler's purpose. So these courts know what's going on. They know what to do. C, trust without definite beneficiaries, 215. The traditional American doctrine is that an intended trust fails where there are no beneficiaries other than the members of an indefinite class, and the discretionary power in the intended trustee to select from such an indefinite class will not save the intended trust. The reported cases are almost always of the latter variety involving discretionary selection. The court says that if there is to be a trust, there would have been no one to enforce it and no reasonable way for the court to carry it out if the trustees did not. Therefore, it is said to follow that there is no express trust, nor is the intended trust to be treated as a power and as such allowed. There is merely a resulting trust. This dubious but traditional assertions about inability to enforce and execute a trust here, together with an unnecessary frustration of the transfer's intended purpose, lead to dissatisfaction with, and so far, growing but modest dissent in the case law from this generally held position of the trust law. That's G. Palmer, Private Trust for Indefinite Beneficiaries, 71 Michigan Law Review, 359, 1972. Example. An illustration both of a classic problem and a traditional result under the clarity predominant line of case law is the failure of an intended trust for such persons, societies, or institutions as the fiduciaries may consider most deserving. Next example. Another classic example is one that is many American states today would come out differently, not because of the different view of the definiteness of beneficiary's requirement, but because of the likelihood of a favorable construction that would limit the purpose to charitable ones. The bequeath to the bishop and trust, quote, to dispose of the property to such objectives as benevolence and liberty, unquote, as he shall most approve, unquote, failed for definiteness in a leading case in England in 1805. And this Morse v. Bishop of Durham, 1805 case where the bishop was ready to carry out the purposes but was not allowed to do so as the trust failed and the property belonging to the resulting trust by textatrix next of kin. So 1. Contrary view, intended trust treated as a power, section 216. So a modest minority of American cases are considered contrary, and it lists Feinberg versus Feinberg, as a view of the second restatement, which is reversing the position of the first restatement. That's restatement second, section 123, and the restatements of the third, section 42 or 46, subparent 2, where it was more structured view. And let's see another California probate code, section 15,205 B2, and UTC 402C, and England's view is also changing. And in Baden's trust, in Baden's deed trust, 1971 case, it lists there that the certain uncertainties of the trust and powers. And then in Beatty's will trust, this view, as long as urged by Ames, would treat the intended trust simply as a power to, in order to allow the intended trustee, if willing, to carry out the purpose within the reasonable time. If not, in fact, carried out by the power holder, even for enforcement purpose in the meantime, this view would treat the situation as if it were a trust for the very beneficiaries who would have taken the resulting trust, with their interest being subject to divestment by the exercise of the power, clearly an arrangement which, if expressly created, could be carried out. And they list the case, their failure of the Tilden Trust in 1892. We could finish the section out. We're almost to the end of the section here. So E, nature of beneficiaries' interests, sections 217. While early cases disagreed with as to whether the beneficiary had a mere personal claim against a trustee, an equitable estate, and the trust res, or both, modern law generally recognizes the beneficiary as the equitable owner of the trust res. I'll repeat that. Recognizes the beneficiary as the equitable owner of the trust res, as well as the holder of equitable rights of specific enforcement. So he also holds the holder of equitable rights for specific enforcement against the trustees to have the trust carried out. So the restatements, the third, the second, part 4, introductory notes. Thus, if a trust involves real property, the beneficiary is deemed to have a real property interest, that is, an equitable interest in the land itself. The minority view, page 62, section 218. In New York and a few other states, the law is or appears contrary to the statute. The beneficiary has no interest in the property, but only personal rights of enforcement against the trustee. And there was a case there that pointed out that in 1882, decided under the New York statute, the court held that it did not violate the alien land law, or a lien to the, alien land law, for an alien to be a beneficiary of the trust of real property because the alien had no interest in the land itself. Even in states that have or had statutes like New York statute, the legislation may not have given the like effect. For example, would a court really treat beneficiaries as general creditors who share trust assets with an insolvent trustee, general creditors? And see supra in section 106. So when it matters, courts have generally recognized under such early statutes that the beneficiary's interest as one of equitable ownership of the property itself. Number 2, incidence of beneficiary's interest, section 219. Various characteristics, treatments, and court discussions of the interest of the trust beneficiaries tend to support their characterizations as equitable interest in the property. However, with the example, the beneficiary's interest may be assignable voluntarily or reachable by creditors, or it may be protected by valid restraints on alienation, and see sections 441. Number 3, equitable conversion doctrine 220. The terms of the trust can affect the nature of the beneficiary's interest. Thus, in a trust of realty where the trustee is required to sell the land and hold the proceeds in trust, the beneficiary often is deemed not to have an interest in the land, but an interest in personality in the sale proceeds. The beneficiary's interest is said to be equitably converted from real to personal property. So we could give an order for conversion. A, note, conversely, if the trustee is required to invest trust funds in a purchase of real property, the beneficiary's interest may be regarded as real property interest even before the purchase is made. An exam tip, whether a beneficiary holds equitable title in real property or personal property may be important where the beneficiary dies, leaving her real estate to X and personal property to Y, or where different substantive or procedural rules apply to realty and personality, even if by acquitted concepts. Example, at common law, real property deceded to the decedent's heirs, and while personal property was distributed to the decedent's next of kin. And see the will summary. Next, page 63, parties to a trust and review. So we have the settler as a required capacity, depends on the type of the trust, and the rights in the trust res. He has expressly reserved rights. Example, life estate, power to modify or revoke, and a reversionary rights. An example, resulting trust. And can the creditors reach the interest? Under the modern view, it is yes. Testamentary trusts, required capacity, must be of legal age and sound mind, know the nature of her act and extent of her property, and who are the natural objects of her bounty, that is, testamentary capacity. And now the donative inter vivos trust, the required capacity, ability to understand the impact of transfer upon financial security. And now the trustee position, under the required capacity, must be able to, 1, take and hold title, and 2, to administer the trust. And the rights in the trust res, the trustee has a legal title, and can the creditors reach the interests? Trustees positions, the creditors cannot reach the creditors. The creditors cannot reach the trust property. Now, beneficiaries, the required capacity, must be able to take and to hold title and the rights in the trust res or equitable title. And can creditors reach the interest? Yes, unless protected by a spendthrift provision. And see infra, section 441 et sequita. Page 64. Extent of interest, 221. The beneficiary's interest, equitable interest, under the trust may be for years or for life, and it may be an interest of indefinite duration, or it may be a future interest. It may be contingent or vested, subject to a condition precedent or subsequent to or determinable, and it may be possessory or non-possessory. And furthermore, the settler may make some beneficiaries primary or preferred custodies case. and others only secondary. 5, form of co-tenancy, Section 222, whereas co-trustees are presumed to hold as just tenants, while rights of survivorship, see supra Section 148, co-beneficiaries of an interest in the res are presumed to acquire and hold their interest as tenants in common unless the settlor expressed another intent. Thus, on the beneficiary's death, any remaining interest she has is in the trust passes to her testate or intestate successors. It does not belong to the other beneficiaries unless the trust expressly or impliedly so provides. And that is the end of the section. And we'll pick up on another section next week. So why don't we open it up for some questions?
All right, folks, if you have a question, go ahead and hit *8 on your phone, and I'll see you pop up here.
That was pretty dry, that section, but...
Yeah. Got a couple questions. Let's go ahead and have Rhonda come on. Hey, Rhonda. How you doing tonight?
Hi. I'm good. How you doing?
Doing real good.
Hi, Christian. Did you have a call last night?
Yes, I did. I was trying to catch my breath there. Yeah.
Oh, okay. Well, I
Did you get on?
No, I tried to get the numbers. I tried to call the numbers I had, but there wasn't nobody talking.
I think it was the 712 number.
Yeah, I called that.
At 10 o'clock.
Yeah. I didn't hear nobody. So I was just checking, see if I had the right number.
Yeah, I think the other ending number was what, 007 something? With 2. Let me see.
702-473-3463 is what I called.
Yeah, 712-432-0075.
Oh, 712-432-0015?
0075.
75.
Yeah.
And
the PIN number was 917030 pound.
Okay. Okay. Well, that must have been. Yeah, I didn't have the right number.
Didn't have the right number.
Yeah. Glad I got that straightened out. Thank you.
I guess everybody liked that when they said that was a good one, so I kind of went over things from like A to Z on an example. Well, I'm finding out there's a lot of people, somebody sent me an email that he said, he went over the website and things, and I don't know how many shows he's listened to, but at least one, but that may explain his question, that he said he really wasn't getting the application of what we were talking about. And he had some things he gave us examples of. He got some IRS problems and some things, how basically what he was saying was, how does trust apply to some of these things, I guess. So I don't know how many shows he's listened to, but, you just can't get the take on this by listening to one show. And if you just read through the website explaining the workshop, really it boils it all down is this is a new remedy. Trust is a new remedy, and it really applies to every facet or problem that you might have. It's not limited to any particular one thing.
It's kind of like having a stroke and learning all over again.
Yeah, and you're still kind of paralyzed from the stroke, yeah.
Yeah. Okay, well, will that be the same number then from on?
Yeah, I think what the problem is that we were trying so many systems out, and we got too many different numbers, and then we're kind of like consolidating them down into one number that seems to work, which would be that 712 number for all the calls, and also to get on through the web would be through that Share Plus.
Yeah, I even tried to get on there last night, and it was after 10 o'clock, and it just said this session's over, type of thing.
Yeah, I don't believe I used any Share Plus at that time. Maybe that's why I couldn't get into there. Maybe I should have started it up and put a number on the board there.
Okay. Okay, well, I'm glad I got the number from you. So is that Tuesdays and Thursdays?
Monday, Tuesdays, and then probably any other calls I would have would probably be using that number.
Okay.
Saturday number is by itself, and the Wednesday call is the TalkShoe number. So.
Right. But all the Monday, Tuesday, or any other calls will be that 712.
Yeah, I believe so, because that seems to be the shakeout of all the numbers we've used so far.
Okay.
That 712 number, the reason we went back to that is because that's accessible by Skype.
Okay.
You can just get right in on a Skype call and it doesn't charge you.
Yeah, that'll help a lot of people. Okay, well, thank you, Christian. Of course, that would be the one call I'd missed, the one that was real good from A to Z.
Well, I just got it edited last night, and I just got a roll-in, lead-in, some music, so it turned out pretty good. So.
Okay, and you're going to have that posted?
Yeah, I added a couple lead-ins to some of the other ones, so there's a little bit of music started off, a little more professional looking. So.
Okay,
I'm
well,
learning
great.
how to use all the fancy stuff for recording and things. Compression and.
We've talked about receipts before, like receipts, that you get when you go take a Federal Reserve note and purchase something. Do those receipts have any value to us at all? Any benefit at all?
A receipt from a purchase?
Yeah.
Well, I would say under debtor creditor they have a value, but what is that value really? So since there is
no value.
Money, but I would say that under trust, you could probably treat those receipts as trust res.
Okay. It's a receipt, right?
Yeah, right.
It's a receipt of something that we put into the system.
And according to trust law, a res is just a thing, and it doesn't have to have a value.
Got numbers on it, that's all it needs.
Right. So, yeah, receipt under trust could be put as a special deposit, and then you could, say, order to do a conversion and apply that for whatever purpose, say, for paying an obligation or so.
Okay. Okay, well, that's good to know. Because I've been saving receipts for a long time. I just didn't know if that was meaningless or if it could be.
No, I tell you about everything we've discovered under, say, debtor creditor, for whatever purpose we were using it for, there is probably an equal and more powerful way under trust.
Well, that's good news. I guess I won't throw them away just yet then.
Yeah, because actually what you're doing on a debtor creditor, you're really operating in trust, but you just don't know it. You've got this false facade on it that's hiding the trust that's really operating, and it's called debtor creditor.
Well, that's when you start talking about receipts and, like a deposit receipt. That's kind of the way I see it, is a deposit receipt.
Right, yeah.
Whether it's the bank or the store or Walmart or whatever, it's a deposit receipt.
Mm-hmm.
So, okay, I'll let somebody else get on. Thanks, Christian.
Okay.
All right. Jay, can you hear me? You're on.
Yes, how you doing, Christian?
All right.
I'm trying to put together a court case for child support. Right now I have notice of claim. Me as the grantor, the mother will be the assigned trustee, and the court will be considered a trustee. Now, when I put that on the UCC, should I put it down as a non-UCC, or should I file it as a regular UCC and then put a lien against it? And I'm going to be accepting it for value and settlement inclusion.
And I'm kind of mixing apples and oranges here, so I would prefer to keep it one thing. we've got the accepted for value, the same thing under trust, which is on page 127.
127.
Which is the transfer of beneficiaries' rights.
So should I just make it private, a non-UCC then?
Yeah, because if you're going to do a lien, then you got to have a UCC filing. But if we were doing trust, we would plug in that block where it says non-UCC filing.
So put it in as a non-UCC.
If you're going to do trust, yes.
But what about how would you enforce the case then?
Well, see, if you got a lien under debtor creditor, you're going to have to do it. You complete your process with UCC, and then you're going to have to do a UCC filing separate from a trust filing.
So do two separate filings.
Yeah, you're going to have to perfect your lien first, and then say, perfect your lien first with the UCC, using UCC the way, as a establishment of a priority. And then I would do another UCC with non-UCC filing and use that to perfect the trust.
All right, so would you put a value on it if you was going to file it as a UCC lien?
Well, absolutely, yeah. You'd have to have a true bill in there with an affidavit of obligation, or else you don't have a lien.
Now, I heard something about it could be valued at $144 million.
Really, you can value it at anything that you want because you're the one setting the value.
Okay, so how would you enforce it on the trust side? If you just wanted to handle it that way.
Well, after you got a valid lien, so now I would use that as trust res. And then I would do a non-UCC filing and transfer that trust res after I claimed it on a 1, transfer it on a 3 to the trustee. And have the appropriate records so that I could back up the fact. Because as soon as I transfer the trust property, if that's, say, in addition to, maybe if it's the only trust property, then that's the thing that's going to form the trust. But if there was some prior trust property, then that would maybe have already established the trust, and then I could just do another special deposit using that lien.
Okay. And I have another question. I'm trying to help a friend out. She's getting her wage garnishment from the IRS. Now, I was talking to her about the trust information. Now, should I handle that as a trust, or should I do that similar to my situation by filing a lien first and then doing the trust with the IRS?
Yeah, I don't really advocate mixing apples and oranges. If you're going to do debtor-creditor, stick with debtor-creditor. If you're going to do trust, stick with trust,
But I really don't want to deal with the UCC like that. I'd rather deal with it in trust, but I just don't know how to enforce it, like give it that power.
Well, your enforcement comes in the court of equity because equity is the 900-pound gorilla for the trust.
Okay.
That's where equity is going to compel the trustee to do what he's supposed to do, or is going to compel him not to breach the trust.
Okay. Now, which page should I read Gilbert's book?
Gilbert's on page 127 under section B is really this likened to accept for value, return for value, although it's not accept for value, return for value, it's trust.
Okay.
Where it's referee's rights.
Okay.
So once the lien attaches to the beneficiary's rights, then the beneficiary can transfer his right, and along with the attachment, the lien, and you transfer it to somebody else. And that attachment, that right, then is the hot potato, and somebody else is holding it except for the beneficiary. If that happened to be the trustee and you put that in a special deposit, then, trustee's the one holding the hot potato.
Okay.
But I don't really like a hybrid mixing and matching, because now you got, unless you know what you're doing, you got two separate processes. And I think people got enough stumbling blocks on this trust understanding to get it under their belt first before they go mixing it with a debtor-creditor lien and try to force it through a trust.
Okay.
I think it'd be a lot simpler and cleaner if you just stuck with the trust and took the case.
That's what I want to do, keep it clean. But like I said, I want to be able to enforce it too. Like, people want to say, well, how do you know? Well, how is this a trust? It's a trust because my signature created it.
Correct. Right. You were the grantor. And
yes.
The time that it creates the trust is on a present transfer of trust res property. So whenever I get the trust res, whatever I'm going to use as trust res, when I transfer it to the trustee, that's when the trust forms.
Okay.
It's a lot simpler. A lot simpler.
And when you say invocable trust, would that actually make it public?
A revocable trust?
Yes.
No, I don't. No, we put 3 lines in on the top. We were just playing around with the expressions on there. We listed it as being a revocable trust and modifiable, and so we were expressing the grantor's intent and purpose in just 3 basic lines. So I don't think that really made the trust public.
Okay.
It would be if you put the evidence in that would establish the trust to be, like on the UCC transfer, if you put the certificates in and things that maybe they're generated by the notary and the evidence in, if you put that in public side of the court, then yeah, I would say you would be giving away. But that should be brought in chambers in an in-camera hearing, so that you can claim the trust and then prove the trust.
All right. Thank you.
Then set up that prima facie case as a claim as beneficiary that the trustee breached, and then once you made the prima facie case, which is easy, then the burden is going to shift to the trustee. Court of equity is going to presume that they didn't make a payment and they're guilty. And the only way to get out of that is to prove then, do they have a record of a payment or a distribution? And if they don't, well then the only thing the court wants to know is, when are you? And there's where they come in and order the court to compel them to make a distribution within, whatever the time limit's going to be. If they didn't, then they would be in breach of the trust. They would be in, breach of the wind and they're going to wind up in jail.
All right. Thank you.
All right, next caller just says guest number 2. Go ahead, you've been unmuted.
Hello?
Go ahead.
Yes,
You've been unmuted.
Yes, hi. In section 200, on page 54 you read tonight, how does that relate to termination of the trust in comparison to 217? In other words, the trustee can appoint himself as a beneficiary, and it says the beneficiary can take action against the trustee. How do those two reconcile?
Okay, what was the section again? 200, you said?
200 and 217.
And 217.
One's on 54, 200 is on page 200, and 217 is on page 61.
Okay, 200 is the power of trustee to appoint himself, and 217 is the nature of the beneficiary's interests. And now, what's the question again?
Now, if I understand it correctly, 200 says that the trustee can appoint himself as beneficiary, correct?
Right. Yeah, that's what it says. Trustee to choose himself. Or possibly referring to trustee as the beneficial owner, subject to a general power of appointment. And now 217 says the nature of beneficiary's interest. The beneficiary has an equitable owner of the trust res, as well as the holder of the equitable rights against the trustee to have the trust carried out. So what you're saying is that there seems to be a conflict as in being trustee and also as being beneficiary.
Right, but does that go towards terminating the trust, or?
No, I don't believe so. This is talking about, this whole section was talking about beneficiaries, which is under just the parties, explaining the different positions of the parties and some of the examples of some of the, special hybrids that they've got, like this one here you just pointed out.
Right.
But I think the trustee, as the trustee, has trustee duties, and the beneficiaries has beneficial interest, and only that. So, which one is he functioning as at that particular time?
Right.
So that would come back to the subject to the general power of appointment. So it says here, courts, however, tend not to construe powers given to trustees for vague classes. It says, for the court probably would treat the transfer as a beneficial gift to the trustee, allowing trustee to choose himself or anyone to have the property, or possibly transferring to trustee as beneficial owner subject to the general power of the appointment. So I think probably at that time he's going to switch from being a trustee to a beneficiary.
So what does that mean for us in terms of, let's say things are happening in the environment in terms of, the constructive trust, or people have these problems. Are we trustees? Are we beneficiaries?
Okay, I'm going to ask you, why would you set up the trustee to be a beneficiary? If you're the grantor of the trust, why would you do that? Do you have some specific reason why you would do that?
Well, maybe that's the only person I would trust to protect the beneficial interest. And they're one and the same persons. I don't know.
Okay, well, here it comes down. What is the purpose I'm trying to achieve? There'd be probably more advantages for the grantor to be the beneficiary himself to achieve the results of, say, merging the titles and terminating the trust, or having a separate trustee to be able to compel the trustee to do the duty as beneficiary. I really don't see, they're doing an example of all these possibilities here for examples of statutory trust, but if I'm going to use a trust as an offensive, really, I wouldn't, as grantor, appoint my trustee to be also a beneficiary and have some kind of say-so over the trustee's position.
So in other words, you're saying this is just for constructive trust, not for express trust.
Well, this does not apply according to maybe the particular purpose that I would want to use it for, or I have intended, but they're just giving you an example that it could be this way per the grantor. But I would say that, why would I, as the grantor, want to make my trustee a beneficiary? It'd be kind of defeat my purpose. If he had beneficial interest rights, I would hold them solely for myself. So I would be grantor beneficiary and name some other party, say, to be the trustee. So I really think it doesn't apply to my situation, because I'm not going to in my indenture make a trust with that provision in it. I can't see any purpose for doing that.
Okay.
Well, that was a good question, because they're giving you examples of probably case scenarios that has happened.
And now, what about Section 219 on page 62? How does that tie into the Declaration of Independence?
Section 219?
Section 219 on page 62.
Right. Incidents of beneficiaries' interest, 219, where various characteristics, treatments, and courts' discussions of the interest of trust beneficiaries tend to support their characterization as equitable interest in the property. For example, a beneficiary's interest may be assignable voluntarily or reachable by creditors, or may be protected by valid restraints on alienation. How's that tie in with the Declaration of Independence?
Yeah, because I thought you said that the Declaration of Independence made it our rights inalienable.
Unalienable.
Unalienable, yeah. Right, unalienable. So is this saying that the beneficiary could assign, he can voluntarily assign his
well, under the 1776 Declaration of Independence, unalienable rights means non-transferable. That means you can't get rid of them. You got them. You're stuck with them. And even if somebody tries to come after them, they can't transfer them from you. I like that a whole lot better.
Right, but I'm saying, so again, this is just the modern view, the contemporary view.
Yeah, because they've since we didn't express that 1776 trust, then that allows them to construe it, and they're going to construe it under the modern views because they want it to be alienable, so it's transferable, so they can transfer titles and they can tax the titles under a debtor-creditor.
Okay, cool. But then it goes on to say in Section 441, it goes into the protective trust, which is part of the Declaration of Independence, correct?
Section 441?
Yeah, do we say that that makes a provision to protect the interests of the beneficiary by a protective trust, a protective clause?
441 with the right to transfer. Yeah, so under the modern view, they're construing the right to transfer, and then the protective trust comes in under the 498. And then the discretionary trust under 490.
Right. So now, do we incorporate those concepts into our writings of our trust?
Well, keep in mind that what we're studying here is really statutory trusts that have been construed for the fact that, we never did express a trust. So once we express the trust, well, there's two things we can do. We can either go by the way that we're construing it, or we can go back in and change some things around and get the facts to match up. Because where I see the problem is in the individual master file in the IRS, where you have self-assessed yourself to be the trustee, and that's in conflict with, say, the Social Security account, where we want to be, say, beneficiary on that account.
So are these, this particular 441, would that be something we would include to make the change, the correction?
Well, the right to transfer?
Well, to protect our, so that we wouldn't be, so the creditors couldn't get our benefits.
Well, see, no, I don't think that's the right approach.
No, I'm just asking.
Under this modern view, they're saying that, because under the section of the discretionary trust, under 490, or excuse me, it was 498, the protective trust, says on the rationale, says that the protective trust was intended to reach a result somewhat comparable to, and in fact more secure than. So that's how they're construing it. They're saying it is really more secure than the result of the spendthrift trust, but that it is logically less objectionable. That's their whole motive behind it. That's what they're saying. It's more secure and less objectionable. And in that, the beneficiary can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. Well, you're in violation of that right there by what you said. You don't want to pay your debts. You want to protect it so nobody gets at it. No, I want to pay my debts.
Well, I said they got you.
Yeah. I want it to be an agreement that I owe the debt, and therefore I say I am the trustee. I can pay the debt, and now give me the access to the funds, and let me do the discharge and the set-off, and everything's all taken care of. Now I'm not insolvent anymore. I'm paying my debts.
Okay.
And then if I'm not insolvent anymore, I'm not bankrupt. Now the discretionary trust is no longer in existence because the purpose has been fulfilled. There's no purpose there to be discreet about and withhold because the beneficiary is acting solvent. He's paying his debts. And then he gets the access to the whole trust because now the purpose of the trust terminates. So by doing what they're saying, I'm gaining the whole thing. Then once I gain the whole thing, then we can go back and we can discuss this 1776 unalienability rights that my founding fathers had intended. But I'm going to correct one thing at a time, at one step at a time. But first, let's get in control. Get control of the account.
That's like the domino effect you're talking about.
Yeah, otherwise we'll be outstepping the bounds and we'll be out of step.
Okay, thanks a lot. Appreciate it.
Great question.
Yeah, that fleshed out some things, I think.
David, can you hear us?
Yeah, Christian, can you hear me?
Yeah, go ahead.
Okay, hey, this is Darren. I have a few questions, and in regards to, and this was something recently found out, and regarding also to that guy that has that child support issue, there's some things he can do if he wants to contact me. If you want to give him my email address, he can contact me. He should do a constitutional challenge to that and correct his status through a declaration of domicile, as long as he's in Florida. But anyway, what I want to get back to, the funny thing is, and also in regards to being a resident of, like, whether the state of Florida or anything else, even the term resident, res means trust res, and ident means identify the thing. That's exactly where that term does come from.
Right.
And typically on the beneficiary issue that you're talking about, typically there has to be one of three common denominators to form it, because it has to normally be blood, marriage, or economic interest, similar to like life insurance if it's going on a beneficial interest like that.
Right.
But my question was, and I wanted to kind of get back just on the regarding on. Just several questions. First is on the UCC filing. After you complete a notarial protest, which of course you're filing a UCC as kind of like a notice of interest and a statement of interest. Now, do you have to send that registered typically, or is certified fine?
The UCC filing?
Yeah.
UCC?
Yeah. Do you send that? Can you send it certified, or is it preferable registered? So this way it's kind of like a bill of lading.
I might want to use registered mail on that because really that's all like outside the realm, really.
Okay. Well, getting back to that question then, once you file that, and you're doing kind of like a notice of interest, statement of interest, then you can actually report that, because you're the secured creditor, actually to the credit reporting agencies against that debtor, can you not?
If that shows up in the public side, yes, but I don't know if maybe I would want it to show up in the public side if I'm going to treat it as trust, which brings me back to when you were talking about resident. Resident is being misconstrued or construed because we didn't express it to be a trust, to be under debtor-creditor.
Mm-hmm.
I wouldn't have any worry about resident because I'm going to have the evidence of a trust that is going to be only introduced in chambers, and there should be no known facts on the public side to give them any kind of challenge to any resident or being trust res property.
Okay.
They'll never know.
Okay, so in other words, let's say you defaulted on a private, you defaulted somebody via notarial protest, via tacket procuration, and now you're making a public notice of a private declaratory judgment by default. Now, in a way, isn't that public, but all the terms and conditions and the facts of that matter is actually private, even though you're making a public notice of it?
Well, the public notice would be in existence of an RA number as far as I'm concerned, and what are they going to glean out of that if we, go by the example we gave before, because it only gives an existence publicly of an RA registered mail number referencing documents held in the private, and nobody knows what those private documents consist of.
Well, until a case is filed.
Yeah, until the private parties come about, and then we got an in-chambers hearing.
Right, but typically when you do something like that, just because of their own acts of dishonor, and by procuration, which technically you're becoming their attorney, it would probably be in your best order to file an ex parte summary judgment against them, since they've already acquiesced on all the previous demands for them to respond to the issues of controversy. Wouldn't you agree?
Yeah, I could do that, yeah. Or I could run a simultaneous process under debtor-creditor, which would be a colorable side, really disguised, holding the real thing running the show, which is my trust action on the private side.
Okay. I had another question, was also in regards to now, because I have a buddy that has had a hell of a time with an association down there in Miami, and this attorney tried to screw him and everything. Now, you were saying, are most homeowner associations, most of them are not incorporated, or can they also be incorporated?
Right. The homeowner association itself is not incorporated, but then when they come at you with an action, we found out that the corporate name was not the association. It had similar wording in it, but it had incorporated in the verbiage, in the title. And that was not the homeowner association that was on the deed or the PUD agreement.
So where would he locate that? So in other words, because he's been sued in court, they got him on like $50,000 attorney's fees by this one. Now,
the association really can't sue you, so they cook up this corporation with a similar name, and that's what sues you.
Okay,
now
so what should
act under capacity in Florida and challenge the capacity because they're not the same entities that's on the PUD agreement.
So what should he be looking for? This is a little bit out of my range.
If he's in Florida, have him check out his PUD agreement, his Plan Unit Development Rider, and look in there for the specific wording of what the title name of the association is, and then compare that to who is actually suing you as the Association Incorporated. And you're going to find there are two different names. That entity that's suing you, the incorporation, has no standing to even bring a challenge into court because that's not the entity that's on the PUD agreement. Right.
Once again, real party of interest.
Yes. No, they're not real party of interest. And there's your proof.
Right. Okay. So, all right, that answers that question for him. And also, I just want to be sure on this UCC1. So that's kind of just like once you complete the notarial process and file the UCC1 into the state, and then you file it into the county. I prefer to go to the state first. This way the county can kick it back because, they do anything they want with the counties. Now you have public documentation, and that will also help you assist. Now you open up a court action, ex parte summary judgment, and we're just talking about it. And then when would the UCC3 come in? After you get a win, a declaratory judgment?
No. Well, I opened the case up. I could take the case and then refer it to make that case into trust res property and then file a UCC. And I got a judge, and he's the judge. He's going to be the trustee on the case. And I'm going to do the 3, transferring the trust case, which is my special deposit, to him. And at that point on the 3, it's been transferred, and now there's a trust.
Okay. So then you transfer it from the 1 to the 3. Okay. All right. That pretty much that pretty much answers my question. And
the UCC1 is just claiming the title that I got the right to move it, and I'm going to transfer it. And it's the 3 that's more important because the 3 is the establishment of the evidence that supports. That's when trust res property was transferred, and that's when the trust was formed on the 3.
Okay. So basically, the 1 just kind of sets it up, but the 3 is really the kicker. But it all goes into a procedural order.
Yeah, it's a 1-2 punch.
Okay, very good. If you ever have any...
Up the 3 is the one knocked down because that's when the trust is formed.
Okay, great. Yeah, if you ever have any time, email me back. I'd like to try to chat with you sometime, if I could, maybe on Skype or something. But I know you're busy just like I am. But thank you for the information tonight, especially my buddy will like that on the association.
Yeah, that one there, you look on that put agreement, you'll find out that the association coming at you and the complaint is not the same name because that's a corporation, and the association has no corporation name.
All right. Thank you so much, Christian. I appreciate it.
All right. Next one is a non-member. Go ahead and state your name and where you're calling from.
Eric, Florida. Hey, guys.
Hey, Eric.
Hey, I had a interesting, eventful day that I'd like to share with everyone. I went to a hearing locally, and it was to be a witness for a person I met through my county assembly who's utilizing Tim Turner's process. And she went in to the at-law, colorable, public side of the court, and while the judge did not dismiss her counterclaim, he clearly did not recognize her as a person on the land, as a flesh and blood person. All he could do was recognize her corporate, her straw entity, and not honor anything that she did because she didn't go into through the process of doing an NOI and a protective order to get into chambers, even though we weren't in an actual open public courtroom. We were in a room with a long conference table, and they said it was a public proceeding. It still was it still proved to be a public proceeding based on the way that the judge acted. Because even though she has this counterclaim that she's filed and she's defaulted them through an administrative process, I saw it with my own 2 eyes today that he did not recognize anything that she did, and I now know why, and it's because she did not get into the private, so she could express and be the 900-pound gorilla.
Right. She waived her substantive rights as a real woman because it wasn't in chambers.
And to see the...
That's 90.506 of evidence rules.
And to see the other attorney, he said that her documents have no basis in law.
And he's right.
And he's right. And it's exactly what I thought of because she's in the public side of the court. They can't recognize it because, as you said many times, it's too much truth. Right, Christian?
Right.
Okay.
If it had been in chambers, it would have been a whole different story.
Right. And the judge she even asked the judge if he read her counterclaim. He said, no, I don't have to. And again, that's because he can't recognize her in a private capacity, can he?
Correct, yeah.
Okay.
Also, one other thing. Did she file a summons for the counterclaim?
Oh, no.
That's a big mistake there.
Well, I brought a disc with many of your audio files on today to share the light with her. So hopefully she'll not only recognize Tim Turner as somebody who's had some successes, but also go and listen and then discover exactly what happened today and for all the reasons that it did. So she'll see the light instead of staying in the black forever. Because I was watching the black right in front of my eyes.
Well, here's what I would have done. I would have said, okay, I would have put a notice of the counterclaim in, but then I would have paid the filing fee for the counterclaim and then had it served with a summons. So they had to respond. Now I got a valid counterclaim. And then all my private administrative documents, because it sounds like she's doing debtor creditor stuff, then I would make sure that is, just a notice of that in the public side. And then all the other details of the counterclaim and stuff, that's just solely in chambers. I'm going to set it up for a protective order. And then we'll talk about that in chambers.
And then she could use the counterclaim as her trust res, right?
This is not treating it as trust. I'm just spouting off debtor creditor stuff. Not even going to trust it pertaining to this. It sounds like she's doing debtor creditor. So it was important for her to file the filing fee to make it a valid counterclaim. So now they must respond. If they didn't respond, now they could certify a default for non-response. But the fact that she didn't do a valid counterclaim according to their rules by paying the fee and have it served by summons by a sheriff, then, you know, they don't have to respond.
Because she didn't do proper service.
Yes, right.
And at the most basic rules. And I even told her, I said, just like you said a couple of nights ago, you know, you got to go through the process, the rules, for them to recognize you in that venue. Even if you're going to get into chambers, you still got to follow the rules for the NOI and the protective order and whatever else you got to do to get to chambers. You got to know the rules in the public up to that point, obviously.
Right. We were reading in Monday class that in that trustee manual there on law and trust, it says really that, you know, it became a very, very clear now after we read it was on the second page, it's talking about the subpoena. When they were talking about the subpoena in there, it occurred to me, now I know why that a summons is used and a subpoena is used. The summons in the corporation. And then when whoever shows up, that's going to be the surety for the corporation for the summons. Now, if they don't come in later on through the case, you don't ever use a summons again except for counterclaim, but you use a subpoena then. Once the live man is identified, then you use the subpoena to subpoena in, say, that party into a hearing. So that made perfectly clear the difference, why they use a summons and why they use a subpoena. The subpoena is for the real man and the summons is for the corporation.
And if she fails to issue the summons for the counterclaim...
She failed to summons in their corporation on her counterclaim.
Okay. So I'll bet you she didn't affect process. I'll bet you. Because she's so stuck on her documents that they stand on their own because that's what Tim Turner told her. And nothing against Tim Turner. He's got a lot of followers and quite developed this stuff a lot. But, I mean, if they're not teaching her to do the summons, then she might as well have done none of it.
Right. She's in Florida. She needs to read the 90.506 and 507 rules of evidence.
And another thing, that both of them, in the hearing, both her and her husband identified themselves as trustees.
Okay, that's probably too much truth in the court right there. You know,
Right, and of course, if they identified themselves as trustees, this was for a car loan that she's done a administrative process against a bank for, and then they acquiesced, and she sent out the notice of dishonor. Then she did the counterclaim against their claim and I guess their complaint in court, and when she but on of course from that document that she signed when she signed the note was she. We know that the bank will name us when we sign the note as trustees. Mm-hmm. So for her to even announce that in court and say, hey, I'm going to pay the bill now by saying that she was trustee, do you feel like she just shot herself in the foot?
Yeah, in open court, yeah.
That's exactly what I thought of. I mean, I just when I saw that happen, everything that you've been talking about just played out right in front of my eyes. And I said, there's validation of what he's saying. And I really think the judge was very kind and lenient upon her because he didn't dismiss her counterclaim. He gave her 45 days under 1.110C, which is a rule, I guess it's rules of civil procedure, which I haven't looked up. You probably know it off the top of your head, don't you, Christian?
Which rule? I forgot what you're talking about. For rule what?
Rule 1.110C. He said she has to respond to their complaint under that rule, I think.
Oh, yeah, that's the summons, yeah.
Oh, that's what that is. 1.110C is the summons?
That's the service of the, it's got to be served properly through summons. She's got to pay the filing fee for whatever the cost is to get it so that it's served by the sheriff.
So the judge totally threw her a softball today.
Yeah, because that summons is what's going to summons in their corporation, or else she doesn't have a valid counterclaim.
So, I mean, do you know for a fact 1.110C is summons in Florida civil rules?
Well, look.
Heck, I can Google this just as quick as you can look, right?
I got it right here. Okay, that's general rules of pleading. Okay, so that's the affirmative defenses. Well, she didn't have a valid counterclaim.
She what?
She doesn't have a valid counterclaim.
He didn't even read it. The judge.
Well, that's probably why, because like he said, 1-110, general rules of pleading. D is affirmative defenses.
So she didn't meet all the elements, right? Likely.
Well, I think it still comes back down to what I said there, the summons.
Okay. All right. You got to start at you got to start with A when you're going through the alphabet, I guess.
Yeah, I don't know what her how her wording was on her counterclaim.
Right.
That she's using that private administrative process and the certificates of the notary and all that they didn't respond, and she's got a valid claim from that, you know. But she didn't. Number one, she didn't put the summons in. Pay the filing fee for the counterclaim. I find that's the biggest thing everybody makes a mistake on. When they file a counterclaim, they don't have a valid counterclaim because they don't make it a valid counterclaim by paying the counterclaim fee and get it served by summons by sheriff. Now they've got 20 days to respond to you and answer. If they do not answer you within the 20 days, then you can go for a default judgment because they default. You get that from the clerk. You don't even have to go to the judge. If they don't answer your main counter complaint, that's the purpose for filing, because the clerk then becomes the timing sequencer, and after 20 days, I give them 25 days, I go to the clerk and say, hey, did you receive back anything from this counterclaim? And if they say no, well, here's my order. Would you please sign that for a default?
And then you just go to court for summary judgment after that.
You wouldn't have to. You already won.
Okay.
They never responded. And you can have the clerk certify a default on the main complaint or the main counterclaim.
Once again, we will fail for the lack of knowledge. We will perish for the lack of knowledge in the most basics of all this.
Right.
Okay. And I tried to talk to her about if she's even gone through the civil rules to make sure she has all the valid elements for a counterclaim, and she goes, I don't need to do that. It will stand on its own. My documents stand on their own. I said, well, they're not going to stand if they don't have all the elements because the judge can't recognize.
That doesn't close the public side.
Repeat that?
What she did closes under commercial the private side. It closed the private side. But now she's in their court on the public side, and she's looking for a public recognition of her closure on the public side of what she did on the private side. And she doesn't know how to go in there with the right thing to get the closure on the public side to get them to recognize her private settlement.
Which would be a NOI and a protective order and then a UCC1 and a UCC3, right?
Yeah, but if she did a counterclaim paying the fee, she might not even had to go that far. And if she would have set it up on the proper affirmative defenses, what the judge was pointing out under that rule 1.10, that she would have had in there, upon the default that everything would be, with prejudice.
Dang, it's so simple.
And the clerk could have certified the default in 25 days, and then she would have just won. And then she would have incorporated in her private administrative remedy in that without putting too much information in there, like putting the RA number in the counterclaim. That would incorporate that default judgment, including the private administrative judgment on the private side.
And then once she did that,
the end of the case.
Right. And then after she won that and she got the certification by the clerk, then she could lien them up to collect, right?
Yes.
Okay. And then it would be a valid lien that she could go to court for enforcement for if she needed to.
Yeah, but she had to come into the foreign judgments law.
Tell us about that, Christian.
Well, actually, she's got a foreign lien. She's got to bring it into the Foreign Judgments Act.
Okay.
Which opens everything back up again, though. That's trouble. Although, but if you got the numbers included in on the complaint and they got the default judgment, then it wouldn't. Let's put it that way. If she would tie the two together, if she would tie the private side with the public side, she would have got a default judgment, that would have included the private side. So you wouldn't have to bring it in under foreign judgment.
Because they can recognize it.
Well, it would be recognized under then because your RA number would pull it in.
Okay. Let's see if there's any other notes I made here that I can share and see if everybody can learn from. What I thought was really interesting is we're in this room, and there were me and another witness to witness what was going on. And if we were to walk into any public courtroom and just sit down and watch, the judge doesn't ask who you are. He just says, okay, there's somebody sitting out there. But in this room where this judge said it was a public hearing, he said, who are you? And he made me give my name. Or he said, you got to leave the room if you don't. So I was wondering, if this is a public hearing, isn't anybody entitled to witness what's going on?
Well, I think he was aware of what was going on with her administrative remedy and stuff, and they're trying to hide that truth from everybody else.
Okay.
But he said if you didn't give your name, you had to leave the room?
That's what he said, yep. So you think that was just a dirty trick?
I don't know. I don't know.
Okay. Maybe somebody else will have some comment on that. I think that's all I got. If you have anything else that you want to share with us about it, great. And thanks so much, Christian.
That's strictly debtor creditor stuff there, but like you said, if you saw a trust functioning, really, the disguise of debtor creditor. And really, I would have rather treated it as a trust from start to finish.
I couldn't agree more. And seeing what I saw today, there's no way I'll ever be in that colorable side of the court now. No way. There's no way. They can't hear me. They can't see me.
Yeah, Florida Rules of Evidence 90.506 and 507 pretty much explains what happened there.
Christian, have you done a protective order here in Florida for a note yet?
I haven't, no.
Do you have anybody who has that maybe could share the model with us?
I think there was a couple guys working on it, but you want a pattern after Federal Rules of Civil Trials of the O'Connor's Federal Rules.
Yeah, I saw that. I just haven't ordered it yet.
I've got the, they give you a CD along with that. It gives you a lot of documents that you can pattern stuff off after.
Well, if you want to share the protective order with me, I would be very, very appreciative.
Yeah, okay. Send me an email and ask me for the protective order example for O'Connor.
That would be much appreciated. Thank you so much.
And everything's patterned after federal anyway, and they got pretty much the whole gamut of what all the elements and stuff are for any kind of cause of action, and a good pattern to pattern and after. That way there's no loopholes left open that they can get out of. Okay, next question.
Yeah, guest number 2 popped back up here. Go ahead, you've been unmuted. Rhonda Ray. Rhonda, can you hear us?
Oh, hi. Just back to earlier when you was talking about, was it under 217, about being beneficiary sometime and trustee sometimes, under the general power of appointment. Would that have to do with, like, the SS5, were appointed as being beneficiary, and then on the 1040, we've appointed ourselves as being trustee?
That might be, yeah. And what you said, yeah, that's good thinking, yeah.
And since the, like earlier when the man was talking about with the IRS and have an equitable title, and it's the beneficiary who has the power to enforce. So as of right now, the IRS sends you the bill. They're seeing themselves as the beneficiary with the power to enforce, and they're seeing you as the trustee because of your confession to being so. Is that not right?
Right, and since that's the master file, and all other agencies must, jive with that. So.
Yeah, so it's not us. It's not us as beneficiaries going after them to enforce. They're the beneficiaries coming after us to enforce, or enforcing us to pay the bill.
Right. I think they're actually coming on behalf of the United States.
Right.
I think they have an agency position with the U.S., and the U.S. is really the beneficiary.
Right. So they're holding equitable. They're actually holding equitable title, and we as trustees are holding legal title.
Yeah, because you self-appointed yourself to be trustee status. Yeah.
So they send us a bill. The beneficiary sends the trustee a request to pay a bill. As trustee, we can pay that bill and send the trust res property back to them. And
yeah, only after we've expressed that there is a trust. Even though they know there's a trust, we've never expressed it to be a trust.
Right. Once and the expression of that trust, say for a bill for the year 2008, the title for that trust would be the 1040 form for that year that you signed.
Yeah. Yeah, there's some background noise. If you're not speaking, could you press mute and then come back in with a question later? Okay, go ahead, Rhonda.
Did you get that last question?
I got that cleaned up.
Repeat it again, would you please?
Okay, let me see if I can remember. Shoot. I can't remember it now. It left my head.
There's something about the trustee coming back in. The beneficiary.
Yeah, you were saying claiming express the trust to begin with, because even though they know it's a trust, that we haven't expressed it.
Right.
So the title, say you got a 2008 return that you signed, identifying yourselves as the trustee, and so now they're the beneficiary on that 2008 return. So
right.
Would the 1040 form on that 2008 return, would that be the title to the trust for that year?
I think it's titled to the claim that they're making. So be the Foreign Situs Trust or the SETI Key Trust. The birth certificate, Social Security account. So I think they're actually creating a claim to get into that account by that bill.
So actually the year that you signed on for, 2008, say, as the trustee, that's not actually the title to the whole trust that you want to claim. That's just the title to that trust res property for that year.
Yeah. Mm-hmm.
Okay. So even if we just want to move if we're just moving the property, that they already know that we're trustee, or they want us to be trustee. They're sending us the bill.
Yeah, but if I establish trust that I was trustee, then that would give me the right to have access to the funds. And if I'm going to pay the funds to the beneficiary, then the trustee's got to be the party who's going to do it.
Okay.
But in order he'd have to have access to the funds, and the only way to have access to the funds is if he proved that it was a trust and he is the trustee.
So if you just was dealing with something for that year, you'd want to claim the 1040 form that identifies you as the trustee.
Yeah, as trust res property.
Yeah, and that's all trust res property, and then that would give you the authority to pay the bill back to the beneficiary. So really, as a trustee, we don't
trust, and then I could use that actual present bill as trust property as payment.
Right. And so as trustee, when we do that, and we assign that trust property back to the beneficiary, because they're the beneficiary, not us, at this point.
Correct.
When we assign that trust property back to them, we're really not enforcing anything. We're just paying the bill. The beneficiary has the authority to enforce us to pay the bill. So really, we won't be going to court. We pay the bill. We won't be going to court making a claim because we're trustees. Only the beneficiary can make a claim. Really, all we have then is
claim by that bill that they sent you.
Yeah, and then once we're the trustee and we move the property back to them, we're really not enforcing anything. However, we're setting up evidence and witnesses that we did pay the bill. In case they do come after us later as beneficiaries to enforce and say, hey, trustee, you didn't pay the bill, we got our evidence and witnesses that, yes, we did.
Right. By special deposit.
Right. Okay. Thank you. Just wanted to clear that up.
And then I might want to give them an order to convert trust property to whatever is payable in their realm, where they're using as currency, say, and apply that to the counterbalancing. Do the order for the set off on the private side and an order for the discharge on the public side.
Okay.
It was kind of like that same model that we went over last night. So maybe I'll get that download for yesterday.
Yeah. Well, I just heard the gentleman or the man talking before about, the 1099, and it sounded like he was thinking of himself as the beneficiary, and that's not how they're seeing it.
I don't think so. No, not until you go back into that master file and correct it. You got yourself established as trustee.
Yeah. So trustee, we don't enforce nothing. We just pay the bills. The beneficiary does the enforcement.
You're the receiver of the bills and the ledger of the documents and the payer of the documents, the bills.
Yeah. So really, as a trustee right now,
you got the legal title, you got all the liability with it.
Right. And so all we can hope to do at this point until we get everything straightened out is to create evidence and witnesses that we did pay the bill.
Yeah, although you could do, claim trust and prove trust,
On the big trust?
On the SETI Key Trust? Because that's the funds they're trying to get at.
Right.
I could use that as the sub-trust grantor on that trust and prove that, and that would give me standing to make the payment then as the trustee.
Well, if we're going to go back that far and deal with the SETI Key, we'd probably be just better off to make ourselves the beneficiary and then the trustee, wouldn't we?
That may take a little longer.
Okay. Okay, so right now you're just talking about,
handling just that one specific instance for that particular year by proving that I'm grantor on a SETI Key Trust and sticking with the trustee position and making the payment.
Okay, and getting your evidence and witnesses that you did that.
Right.
In case the beneficiaries get a cob and say, hey, you didn't pay trustee, you got your everything you need there to show, like you said, you're guilty unless you can show you made payment.
True. Right. That's the only way you're going to be able to get out of it.
So we can
come in and say that I'm discretionary trust here and I can't pay the beneficiary because that may be a little bit harder to prove.
Right. Or I did pay it.
Well, the beneficiaries, which is really the United States, is insolvent. They're bankrupt, and I can't disperse the funds to them because it's per discretionary trust.
Right. You can do it that way, or you can pay it and then have the evidence that you did pay it.
Either way, yeah.
Okay. Thanks.
Either way, you're going to win.
Right.
Well, Christian, that's all we have for tonight.
All right, good. All right.
Really great questions, though.
So this is Wednesday. So next meeting is on Saturday. But everybody listening, check on my website at movingtitles.com. If you just type that in the browser, but I guess it's starting to come up on a Google search now. So If you do a Google search, it'll come up. But anyway, just press in moving titles. Excuse me, what is it? Movingtitles.com. Yes, there it is.
Movingtitles.com.
Movingtitles.com, yeah. And check out the website because I'll be updating that all the time. And I'll be putting different links on there and information and clarifying some things. And so keep checking it back with that, and because it'll be changing. All right, so I guess that's it.
Thanks, Christian. Appreciate your time tonight.
See you Saturday or next week. Monday for the trustee ambassadors, and Tuesday at 10 o'clock on that 712 number, and again on Wednesday. We'll see you back here again.
All right, folks.
Thanks, Matt.
Have a great evening. Thank you.
Hey, Matt.
Hello.
On the handbook for the federal codes, should that be the O'Connor's handbook, or can we just get a Weston Thompson handbook, federal handbook?
The O'Connor's book I was talking about, it's titled O'Connor's Federal Rules.
Okay, so we don't need the big one then, the regular federal handbook.
Well, I also have that one too. I have the actual Federal Civil Judicial Practice and Rules.
Okay.
Judicial Procedures and Rules, excuse me.
Okay.
But that is free. You can go down to on the internet and pick that up.
Oh, you can?
Yeah, you can get the federal rules off the internet, but I might not have all the official comments and things though.
Oh, okay. Oh man. Thank you.
But I like for litigation, I like the federal rules and civil trials. That's the O'Connor's Federal Rules. I like that, and I like the Federal Civil Rules Handbook. Maybe that's what you were talking about also.
Yes.
Okay, yeah, those two go together. O'Connor's and the Federal Rules Handbook, yeah.
All right, thank you.
All right. Well, good night, everybody.
Night.